In the next minutes, I will talk about what international humanitarian law says regarding the protection of missing persons and their families. And in the second part, I will try to present 3 challenges related to the practical implementation at the national level of international humanitarian law, and how these challenges relate to clarifying the fate and whereabouts of people who have gone missing in armed conflicts, and how states need to implement these obligations at the national level in order to uphold the rights of families of missing persons to know. First of all, I would like to recall that the rights of families to know the fate and whereabouts of their relatives is a right that is recognized in international humanitarian law, but also in human rights law. In this regard, the family's right to know means that families have the right to be informed about all the measures undertaken towards clarifying the fate and whereabouts of those who have gone missing. Under international humanitarian law, the rights of families to know appears in Article 32 of Additional Protocol 1 to the Geneva Conventions. This right is a principle that should guide parties to the armed conflict and also humanitarian organizations like the International Committee of the Red Cross when addressing the issue of missing persons and their families. The right of families to know the fate of their relatives is also supported by numerous resolutions adopted in multilateral fora. For example, in 1974, the UN General Assembly stated that the families have the right to know what happened to their loved ones, and that this is a basic human need. Furthermore, the former UN Commission for Human Rights and as well the UN General Assembly have recognized the right of families to know in situations of armed conflict. In addition to this, the International Conference of the Red Cross and Red Crescent Movement has adopted numerous resolutions stated that families have the right to know the fate of their missing relatives in situations of armed conflict. So bearing in mind the right to know, and also bearing in mind that this is the principle that should guide parties to the conflict when addressing the issue of missing persons, I will now talk about what IHL says in terms of obligations. To put it in very simple words, we can say that under international humanitarian law, there are 2 general obligations to prevent people from going missing. One obligation is to prevent, and the other obligation is to clarify the fate and whereabouts. So to understand what the obligation to prevent people from going missing, allow me to give you some concrete examples of what IHL says in this regard. So for example, you will find in international humanitarian law provisions saying that parties to the armed conflict, they have to provide for means of identification for its armed forces or also armed groups, like identity tags or discs. It also provides that it is important to ensure that all people at risk are registered, for example, the wounded and sick, children, the elderly, people with disabilities, and also people who are deprived of their liberty in detention. It also provides, in terms of the management of human remains, for all the information regarding human remains to be registered, also that death certificates are delivered in an appropriate manner. So all this series of measures will prevent, if respected, people from going missing in armed conflict situations. The obligation to clarify the fate and whereabouts of missing persons implies 2 things in general. First, the obligation of parties to the armed conflict to account for all those reported missing and to provide any information they have on their fate, and the obligations related to the management of the dead, in the sense that parties to an armed conflict, they must take all possible measures to record all available information they have on human remains. They have to mark grave sites as well. So ensuring as well these obligations and taking measures in this regard will reduce the number of persons unaccounted for and will help to clarify the fate and whereabouts of those who have gone missing in armed conflict. Finally, also I would like to mention that under international humanitarian law, there is a rule in customary international humanitarian law that says, and that is very important, that enforced disappearances are prohibited. So now I would like to discuss and to mention 3 challenges related to the implementation of international humanitarian law at the domestic level. The first challenge relates to the fact that there is no legal definition under international law of who is a missing person. Of course, there is the very important definition of enforced disappearances under the Convention for the Protection of All Persons from Enforced Disappearances, and also as well the definition of enforced disappearance as a crime against humanity under the Statute of the International Criminal Court. But, like I mentioned before, there is no international legal definition of missing persons as such. And this creates some challenges, especially when working and addressing this issue at the domestic level. When defining who is a missing person at the national level, it is very important that 2 elements are provided in that definition. First, an element of uncertainty of the fate and whereabouts of the person to his or her relatives, and secondly, that the person has been reported missing on the basis of reliable information and in connection to a particular situation. Be it, for example, now that we're talking about IHL, to a situation of armed conflict, but also it could be, for example, in relation to a situation of violence or to a particular situation of a natural disaster, for example. When adopting domestic laws and policies and measures that will address the issue of missing persons, it is very important that the definition is as broader as possible in order to avoid that some people might fall outside the scope of application of a particular law that is being put in place to address this situation. In some cases, the law would limit the scope of application to a specific period of time, for instance, to a specific armed conflict that took place in a particular context, and this is completely fine. And in practice, we see some examples of laws that define their application regarding to a particular situation. So moving to the second challenge, which is somehow related to the definition of missing persons. And the second challenge relates to the importance of recognizing a legal status for missing persons at the domestic level. And that this legal status is also recognized not only for the person who has gone missing, but also to their family members. And to explain a little bit what this challenge entails, I'm going to give you an example that would illustrate clearly this challenge. So in a particular context, the ICRC carried out an interview to families of missing persons, and it interviewed a woman whose husband went missing in relation to an armed conflict. And when interviewed, this woman said that she thinks that when people are born, they have a birth certificate for that. Then when people die, they have the right also to receive a death certificate of that. And she said that her husband went missing, but she doesn't have the right to receive any official documentation for the fact that her husband went missing, which implies that she only had 2 options according to the law, either birth or death. So I think for me this is a clear example that shows that this is an important challenge, and that in some cases families, they have to request for a presumption of death instead for the absence of the person. And this, for me, it is clear that it has quite an important impact on the families of missing persons. In addition to this, it is very important to understand that the absence of a relative entails a series of administrative and legal obstacles. For example, when it comes to the exercise of property rights, of inheritance rights, of parental rights, and also including the right to enter a new union. So in this regard, this is why it is very important to ensure that the absence of a person is recognized at the national level for families of missing persons to be able to surmount all these administrative and legal obstacles that they may have. Finally, an important point that I would like to raise is related to the application of IHL in, for instance, once a conflict has ended, or in post-conflict on transitional justice processes. Why? Because sometimes we can think that when a conflict ends, international humanitarian law stops to apply. but there are some specific obligations under IHL, like for instance those related to missing persons and to the management of the dead, that continue to apply even if an armed conflict has ended. In this regard, what I'm saying is that every process that is put in place even after an armed conflict has ended should take into consideration and should be based in processes and institutions that are put in place at the national level to deal with the issue of missing persons in an appropriate manner. This means that structures that are put in place, for example, need to be able to have procedures to manage information on missing persons in an appropriate manner, as well to process that information, but also as well to be able to respond and to keep informed the families of the processes in clarifying the fate and whereabouts of their loved ones. Also, these institutions or processes or mechanisms that are put in place to search and to clarify the fate of missing persons, they need to be equipped with the proper capacities, and for example they will need to be equipped with proper forensic capacities, because in some cases, for example, they will carry out processes to deal with human remains and to deal with exhumation. So building the forensic capacity of these institutions is very important as well. For me, at the end of the day, what is fundamental is that families of missing persons are put at the center of every process, and also that they receive an individualized response about what happened to their missing relatives in a situation of armed conflict, like international humanitarian law says. To conclude about what IHL says and what are the challenges in terms of implementation, I mean, it is clear that international humanitarian law contains numerous provisions to deal with cases when people go missing in armed conflict situations, and also to deal with, for instance, how to ensure the management of the dead in a dignified and proper manner. However, the challenges remain when it comes to the practical application and implementation. In this regard, so when parties to an armed conflict and when the authorities work on the adoption of these measures, they always have to keep in mind that the situation of missing persons needs to be prevented, addressed, and resolved through this whole system that will be put in place to achieve this goal. Finally, I would like to say a few words on what the International Committee of the Red Cross does when it comes to the issue of missing persons. I can say that the ICRC is working today in many contexts around the world where the issue of missing persons exists and is being addressed. So, for example, we can say that the ICRC works in preventing people from going missing, and we do so by, for example, reminding parties to the armed conflict and the authorities about their obligations under IHL to clarify the fate and whereabouts of missing persons. We also do that by providing legal and technical advice to states who are working on the adoption of domestic measures to address the issue of missing persons. We also work on preventing people from going missing, for example, through the work we do in prisons by visiting prisons and ensuring that families can visit their loved ones who are detained. The ICRC also works on searching for people who have gone missing. And this is, for example, all the work that the ICRC carries out in terms of restoring family links or through our tracing activities. And we do so, for example, by working very closely with all the national Red Cross and Red Crescent societies all around the world. Also, in terms of the search, we try to build a forensic capacity in different states. So we provide support to the different forensic legal system in order for them to adopt the proper procedures that are compatible with international standards. And finally, we also work in supporting families of missing persons, because we cannot forget that families, as I mentioned before, should be at the center and are at the center of every process. So we support families, for example, by working closely with them, by understanding what their different needs are, by talking to the authorities, to mention to the authorities, for example, what the needs of the families are and which measures can be adopted in order to respond to the needs of the families.